We also represent clients who have had their children removed by the Department of Social Services because of false allegations of abuse and neglect. Such cases are called juvenile or juvenile dependency cases. These cases are conducted in special courts closed to the public and closed to public scrutiny. Our team members have had decades of experience handling these cases. There is no right to a jury trial in juvenile or juvenile dependency cases. The decisions in these cases are made entirely by a judge, commissioner, or referee, and they rely upon hearsay statements of social workers, doctors, and therapists in determining if a parent has abused a child. There is a general presumption in the juvenile dependency court that the parent is guilty until proven innocent. Well, I know the law doesn't say this, but that's the way it operates. You see, that's just the reality of the way these cases seem to wend their way through these difficult court processes. Children are routinely removed from their parents' custody based upon reports of suspected abuse from teachers, family physicians, therapists, vindictive spouses, and vindictive relatives. Unfortunately, if a social worker merely suspects that there has been abuse or neglect, or that a child or children are at risk for abuse or neglect, the law allows the social worker to remove the children from the parent's home and place them in foster care until the Department of Social Services completes an investigation or the court finds that the abuse allegation is untrue. Rarely, however, are children returned to their parents' custody. In California, for example, there are an average of 100,000 children in foster care every night. All too often, the judge finds the allegation to be true and the children are placed in long-term foster care, while the parents are required to attend countless hours of therapy, attend special classes, and prove to the social workers that the court that they are reformed. A common and yet outrageous strategy finds the social worker advising the parent who is not suspected of abuse to obtain a restraining order against the alleged abuser, kick them out of the house as a condition for returning the children, and perhaps even get a divorce. In other words, they cause a breakup of the family intentionally. We have even seen social workers demand that parents file for divorce and separation as a condition for returning the children. Meanwhile, the alleged abuser is either denied visitation or can only see the children for 1 hour or less a week with a visiting supervisor, watching every move and filing weekly reports describing the event. If the court determines the allegations of abuse are true, the child is declared a dependent ward of the court. Often the accused parent will be sued by the county welfare department and assessed the maximum child support allowed by law. And this will automatically be garnished from their wages and paid directly to the county while their children are in foster care. Children are often removed from their parents' custody for up to 18 months. At the end of 18 months, parental rights can be terminated, and the children adopted out to strangers. For young people, it may be only 12 months before the termination proceedings begin. Most attorneys are unfamiliar with the strange, bizarre juvenile dependency court system. Many attorneys refuse to get involved in the juvenile court system because it is so fundamentally unfair. It is essential that parents be represented by an attorney who has experience with the juvenile court system and has the knowledge to challenge any deviation from the law that the social worker may attempt during the reunification process. Our experience informs us that the system rewards social workers who are able to terminate parental rights and adopt children out because the counties receive federal funding when they adopt children out. The system actually requires the Social Services Department to follow a two-track process while children are in foster care. One track is designed to reunify the child with his or her parents, while the other requires the county to make plans to adopt the child out in the event that parents have failed to complete the social worker's reunification requirements. Often the foster family that the children are placed with has been pre-selected by the Department of Social Services as a potential adoptive home. In this way, children placed in such homes are at substantial risk of being alienated from their parents by the foster parents who are hoping that the reunification efforts fail so they can adopt the child themselves. If a child has been removed because of a suspicion of sexual or physical abuse, parents have an even harder time getting their kids back. The mere accusation results in parents' names being placed on a child abuse central index forever. Unless a parent can prove that the accusation was unfounded and petition the Department of Justice to remove their name from the index, they are almost always on the list forever. There is no requirement that the agency that put your name on the list conduct a thorough investigation. We have seen some social services department attempt to maintain a person on the abuser index even after the allegations were dismissed. When a parent's name is put on this list, they'll be prevented from working in any setting where there are children present forever. They will never be allowed to volunteer as a coach, help out at a school or church function with children, or in any other youth program. Simply, they are labeled a child abuser even if there is no court finding that they're guilty. And as we pointed out, the burden is on the parent to prove that the accusation was unfounded to get off the list. Now let's take a few minutes to describe the juvenile court process. The process is divided into 3 phases. Phase 1 is what's called the detention phase. When a social worker receives information that a child may have been abused or neglected, or that the child is at risk for abuse or neglect, the social worker generally contacts the child or the party reporting the suspected abuse and makes an immediate decision whether or not to remove the child from his or her parents. Children who are of school age are usually interviewed by the social worker at school without any notification to the parents. If a social worker suspects abuse occurred, the child is taken directly from school to an emergency shelter and then placed in a foster home as soon as one becomes available. The social worker will then call or leave a note for the parents of the child informing them that their child has been taken from them and that there will be a petition alleging abuse filed with the court within the next couple of days. In the notice, parents are instructed to appear at the court hearing where the judge reads the petition and determines if there is sufficient cause to remove the child. Having an attorney at this early stage of the proceedings can be very useful in setting the tone of the case and in making sure the court knows that there are 2 sides to the story. Unfortunately, most judges find that there was sufficient cause to remove the child from the parents, and the case moves to phase 2. Phase 2 is called the jurisdictional phase. This is a phase where a trial is held to determine whether the allegations are true. Leading up to the trial, your attorney should receive and review the reports that the department will rely on in proving its case against you. Our litigation members review these reports with our clients in great detail. In cases of false allegations of abuse or neglect, attention to detail is critical because it will generally lead to an explanation of why the accusation was made and why it is false. It is also the time when we can conduct our own investigation and retain our own experts to disprove the allegations. Remember, in reality, in this system, parents are guilty until they are proven innocent. The trial is called a jurisdictional hearing. This hearing is very similar to a criminal trial, except there is no jury, and constitutionally important rules of evidence are ignored. For example, hearsay is generally accepted. The social worker's report can be received into evidence, and it's filed with multiple layers of hearsay. Our goal is to convince the court that the accusations are false and to dismiss the petition. If the court agrees with us that the accusations are false, children are immediately returned home. Unfortunately, when we win, our clients often make a reasonable request for an apology. Don't expect an apology. Why? Well, you see, the state legislature has given social workers immunity from lawsuits unless you can prove that the social worker acted maliciously and gave false statements intentionally to the court. It does occur, and our team members have been involved in some of these cases. Unfortunately, social workers can act negligently and suffer no legal repercussions. If the court finds the allegations are true at the conclusion of the jurisdictional hearing, we move on to phase 3. Phase 3 is called the dispositional phase. This phase is designed to reform a parent and make it safe to return the child.